Hey out there, legal warriors. In this video, I'm going to cover the do's and the don'ts if you are charged with the crime of domestic violence in Washington state. Even if you're not charged with the crime, you're going to want to know these do's and don'ts. If you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington state for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get the help they need. Now I'm just going to jump right into it. When I started as a defense attorney 23 years ago, I'd been a prosecutor for 7 years. And I made, when you're starting out as an attorney, you don't have many clients, right? You have plenty of time on your hands. And so I put out a list on my website a good 20 years ago about the do's and don'ts if you're accused of a crime of domestic violence. And, I was going back through my website and I saw those do's and don'ts still apply today. And if you're accused of a crime of domestic violence or your loved one is, there's a lot of mistakes we can make. And so I'm going to cover the 5 don'ts I'm going to start with, and then the 5 do's after that. So we are able to make sure we don't make any mistakes and get the best help we can if we are accused of a crime of domestic violence. So number 1, what's the first do not? Do not violate the terms of your no contact order. Almost always, if we get arrested for domestic violence, there's going to be a no contact order against us. We need to take a look at that no contact order. We should have a written no contact order that we received when we got released from the jail, or if we went to an arraignment date on our own when the court issued a no contact order in court. And I've seen a case recently where a client did not read the terms of that order closely, and they got arrested the same day they got released from jail. They got arrested again, and they got released from jail a second time, and then they got arrested a third time for violating the order because they didn't closely read the terms of the order. So what might the order include? It's going to usually include you can't go back to your residence. You may not be able to have contact with the alleged victim at all for any reason. You may have to stay a certain distance away from the residence or the workplace or the person of the alleged victim. And that can be difficult to stay that distance away if we are in certain areas where we work close by or we need to get clothes or something, right? And so we need to read the terms of the no contact order and do not violate the terms, because not only will it hurt your original criminal case, as in the case of that client, it's going to add additional criminal charges that we have to deal with. Happily, we were able to get all the cases dismissed in that particular case, but we can't always count on being so fortunate. What's the second do not? Do not talk to the police about your case, especially after the fact, right? That doesn't seem like that could apply, but it does. Sometimes you'll hear from police after an arrest when they want to check up on something, or they want to serve a new order. They want to make sure you've turned in your firearms, right? And of course, we do not want to talk to the police after we've been accused of domestic violence, because anything we say can and will be used against us. So we want to assert our right to remain silent. Talk to an attorney before you end up talking any more to the police, because usually the amount we've already spoken to the police is what's got us arrested in the first place. And I've seen cases where an officer will follow up and they'll ask a few more follow-up questions on a serious case, like let's say a felony arrest, and that client may say additional things that further incriminates them and makes it harder for them to defend their case in the long run. So don't do that. The third do not is do not try to defend yourself, right? A domestic violence case, even the least serious domestic violence case, is a gross misdemeanor, maximum 364 days in jail, $5,000 fine. If you're a non-citizen, there's immigration consequences as well. If you're convicted, you're going to lose your right to possess a firearm. It's going to have a lot of problems. And so it's not like a traffic infraction. If you've never been involved in the criminal system, you may think you can just go to court and tell your side of the story. And it's normal that you might think that's how it works, but it is not how it works, okay? How it works is there's a prosecutor who's a professional who's trying to convict you and do bad things to you, maybe including jail time, maybe ordering you to do a year of treatment, maybe giving you a 5-year no contact order where you can't go back home for up to 5 years. So you want to get yourself an attorney, either a private attorney like somebody in my firm, or a public defender if you can't afford a private attorney, and follow the court's instructions. But domestic violence is one of the most serious charges you can face in Washington State, not only due to firearm rights, but also all the other collateral consequences that come with it, including being thrown out of your own home. So do not do it alone. The fourth do not. It relates to number one, but some people make this mistake. Do not communicate with the protected party by email, by text message, or through third parties, right? When no contact means no contact unless there's an exception written in the order. I've seen this case too many times where, hey, I as the defendant, asked my mom to get a hold of the victim to get some clothes, but the mom says it in a way that's communicating a message from the defendant. Hey, Tom asked me to ask you, could he get his clothes? Well, that's a message from Tom through the mother to the protected party. If the protected party is on Tom's side, then she's probably not going to report it in this situation. But if she's against Tom, Tom's getting arrested again, even though he had no control over how mom put it. There's ways it could be said that's more safe, but you want to check with an attorney first. Similarly, you can't respond to anything that the victim sent you. The protected party can send stuff to you. They're not restricted, okay? But you cannot respond to it. If you respond to it, then that is a new crime. Now, the good news is, generally speaking, the police and the prosecutors aren't going to be monitoring the communication. But if there's communication between the two of you and the protected party, the victim, turns against you, they're going to use that to get you charged with more crimes. I've seen that. It's a common situation I've seen in Shoreline, where they can use communications between the parties that they get from the alleged victim to threaten additional charges or charge additional charges to force pleas out of cases. So you don't want to set yourself up into a position where the prosecutor could leverage additional charges against you to make you plead guilty to a crime that you might not otherwise need to plead guilty to. Number 5, do not go to the address of the protected party, to their home or workplace, to obtain your items, because that, items that you need, your computer, your toothbrush, your clothes, you can't go there on your own. If the court tells you, hey, you have a civil standby to go ahead and get those items, then that means that you have to get a hold of the police and have the police meet you there, and they'll give you 15 minutes or so to pick up basic necessities. You're not going to be able to pick up furniture or things like that, and they're not going to let you take things that the protected party, they don't want you to have, right? But you can't go there on your own. And you want to check with the local law enforcement agency about what their procedure is, right? It's different in different places. Your attorney may know, and your attorney may not know also, because sometimes that happens outside of the attorney. But what you don't want to do is violate the distance restriction of the order. Oftentimes, law enforcement will say, hey, get a certain distance from where you need to be, and then give a call to 911 or give a call to the non-emergency line, and then an officer will meet you. Well, if you have a 1,000-foot restriction and you get within 500 feet and call for that civil standby to the law enforcement, when law enforcement shows up, they may arrest you for being within the distance restriction. I've seen it happen. It's totally nonsensical in my mind, because you're trying to obey the law. But if we're not careful, we can violate the law. We can't go do it on our own. If there's a civil standby, we have to get the officer to help us, because the officer is going to keep the peace during the event, and that's an exception to the distance rule that one time. If no civil standby is listed, then you're going to have to use other ways to get your property, which might include third parties, but the third parties need to communicate safely. If the defendant's name is Bill, they could go to the protected party and say, hey, I'm able to pick up some of Bill's stuff if you want me to, in case you're wanting him to have some stuff. Now, you notice that didn't communicate a message from Bill. Instead, if that third party said, hey, Bill said for you to give me all this stuff. Well, that's communicating a message. Bill said, right? And it's a technical difference, but it's a difference, right? It's a pretty gray area of the law. And that's basically how we advise our clients to operate. Now, moving on to the do's, the things that you do want to do if you get charged with domestic violence. So if you do get charged, number one, the do's, you need to take photos of any injuries you have, photos of any damage to your property, torn clothing, broken computer, whatever it is, broken glasses. You're going to need some evidence to show that if you were in a scuffle, that you also possibly could have been the victim and not the person the police called the victim, right? And those injuries may not show up right away. It's very common for prosecutors to send out people to get photos of their alleged victims later because bruises show up later. Colors change. It might not be there day one. It is there day 3. So we need someone, hopefully besides you, to take photos of whatever exists. And if it's torn clothing, maintain the clothing, that type of stuff. Hopefully someone besides you takes the photo so it can be authenticated by someone besides you, because oftentimes if we get to a trial, we don't want the defendant testifying. And if you're the one who took the photo, we might not have any other way to give it into evidence besides you testifying. And so hopefully it never gets to a trial, but we want you to preserve evidence of anything that happened to you. Next, the second in the do's is do take steps to protect your finances and your property. We cannot assume that the alleged victim is going to be on your side. What if this is a divorce situation where, this was the straw that broke the camel's back and now there's going to be a divorce? Oftentimes, each party rushes to drain the bank account. So let's say that you're financially dependent on the alleged victim, and they do something to get you arrested. Well, you don't want them to just drain that whole account and you have no resources. So try to protect your assets, right? Do you have your own credit card? Can you draw some money from your joint bank account so you have something to live with? I've seen a case where a client was a defendant and the husband in the case just sucked away all the money. And so now the client had no way to live, no way to do classes, no way to get a divorce attorney, right? And they lost that battle, right, as far as who could get to the finances first. Now, eventually in a divorce, that may get settled, but we need to deal with now, right? There's a no contact order. You may need somewhere to live. So you need to protect yourself by trying to deal with your finances in a way that takes care of you. You don't want to do too much that you anger the alleged victim. There's a balancing act, but we have to take care of ourselves because this is something that can commonly happen in a domestic violence case. The next do is very important because of how long a case takes. The next do, the third one, is take notes about what happened. Write it down somewhere. You want to write attorney-client privileged on it in case it's a strange case and a search warrant got served and they got your computer later, which is unlikely. But you want to write some notes down about what happened so you can remember what happened, because it might be months before you're even charged with a crime in some cases. It might be months before you have a court date. And for sure, it's going to be months, if not 6 months or more, before a case gets towards a resolution, and your memory's going to fade, right? The reason why police make reports is so they can have a good recollection later, refresh their memory about what happened. That's one of the reasons why police reports exist. And that's why you need to make your own version of a report you're going to hang on to yourself and you're going to give to your attorney, because those things are going to fade from your mind over time. And also, if you have something like that, your attorney can review it and maybe ask you some questions to fill in some blanks that you didn't think about that was important. What might be important? How much did the alleged victim have to drink? How much did you have to drink, right? Exactly physically, where did everything happen, right? And what did the officer get wrong? And what did the officer get right? I want you to take some notes so you are able to refer to it later, but write attorney-client privileged on there so in case it gets into the wrong hands, there's some claim that the government can't use it against you. The fourth do is, in a way it's a don't, but I'm calling it a do. Do avoid using drugs and alcohol after you get accused of a DV case. I'm going to tell you, in many, many cases with domestic violence charge, there is some alcohol, marijuana, some drug usage that happen, usually on both parties' parts, but the system's only going to look at the defendant, right? And if there's alcohol or drugs in the case, almost certainly you're going to be asked to do an alcohol and drug evaluation later. And if you're asked to do an alcohol and drug evaluation later, we're going to want to make sure that turns out is as positive for you as possible, negative on substances, but a positive outcome, right? Also, if we use drugs and alcohol, we could get back into the same situation. So let's try to tamp down on that. So not only can we have a better evaluation later that's going to show that you don't have problems, but also so we don't get into more problems by making a situation worse by using those mind-altering drugs or alcohol. So let's avoid that. Then finally, the fifth do, and this one may sound self-serving, but it's not. It's do contact a competent attorney right away. And there's reasons for that. You don't have to contact my firm. You need to contact an attorney so they can tell you what to expect. Again and again and again, I will preach that criminal defense is local. You cannot trust what you see on Google for people's websites. That's written generically, and it's written to scare people too. If I were to get a phone call from somebody about a case in Linwood Municipal, I would say, well, here's how I expect this to happen. Here's when court's going to be. Here's what you're likely going to need to do. Here's who the prosecutors are. If I were to have that same call for Renton Municipal, I would say, okay, court's going to be a different time. These prosecutors act a little differently. Here's what I know about the judges. Here's what I want you to do. If the call was for Bothell, it'd be a whole different approach. If it's a county case, I'd be telling you, hey, you're not going to have a court date for 6 months if you're in Snohomish County. You might have one in 3 days if it's King County. In Pierce County, it would be a flip of the coin, right? And so not only do you need a competent attorney to defend yourself in court, but you also need one to let you know what to expect, because it's so difficult, right? Being charged with a crime, that mental pressure of not knowing what to expect, of having no control and being worried about your future. With a competent attorney, we could stop that in its tracks, at least if you listen. Please listen. Can't tell you how many times I say the same thing to a concerned potential new client or the family member, because it's tough to take it all in, and I talk a little fast, but I need you to listen to that competent attorney. And if they're trying to scare you and, hey, you need to hire us now and all this other stuff, then that's something to take with a grain of salt, because typically speaking, the attorney should be trying to inform you what's going to go on, and to the best of their ability, let you know how it is you should behave going forward to improve your chances and hopefully tamp down on the anxiety and not increase it. If someone's increasing anxiety, that's probably a sales technique, and that's not something that we try to do in my firm, and I would advise that we avoid people who put us in that situation. So those are the 10 total do's and don'ts, 5 on each if we're charged with domestic violence. I wrote that 20 years ago, and it still applies today. And if you can pay attention to those do's and don'ts, you're going to have a better chance of getting through a bad situation with a much better result, not only overall result, but how you feel going throughout the whole case. Let's avoid the mistakes. Let's do the positive things, and let's get this behind you as soon as possible. So if you found this video useful, please like and please subscribe. More people get the help they need. And more importantly, if you're charged with a crime, including a crime of domestic violence in Washington State, feel free to reach out to my firm. We've been defending people charged with crimes for more than 20 years. If we get on board, we'll listen to what happened, identify a way forward, and we will be there for you. Thank you.